So I've decided to update this because, I've actually decided to add the Lord Hanningfield representation that Jeremy Johnson did. And it's only 6 pages. To be honest, there's not that much writing there for a legal representation. Seeing that it's like a unique and peculiar specialised area of law that is usually reserved for only a few. It's only 6 pages long, and the last page is only like 3 lines. So I think I got this from the House of Lords. This was available online though. There was a PDF. I got this from the House of Lords under Freedom of Information. This is my copy of it. But it was available online. At a later stage, after I had obtained it, I found it online. It could have been a law website. It might have even been their own chambers that had it on there, or a university, something like that. So it was available online. Obviously, I got it under Freedom of Information for legal study and for the petition evidence. And I've had it for quite a while. Now, I didn't know this though. Persons may prosecute actions against members of Parliament in the intervals of session. That is from one of the George II Acts. I don't actually know which act it is yet, because, embarrassingly, I don't exactly know how to read those citations. I know it's George II, George II, chapter 24, volume 17, of what though? But I got this, there's loads of little snippets of law that I found in this index, but they're all indexed alphabetically, so under like P for petitions, they're all the legislation that regards petitioning. These are from statutes at large. Some of the statutes at large seem to be kind of like just volumes of law relevant to certain things. Like, for example, you could look up carts, and there's loads of law to do with carts all the way through. I think what it is, it's all of the legislation through all of the statute law, like the whole archive of, like the main bulk of archive of statute law, the main statutes. It seems like they've got all the laws that are connected to any particular thing, like petitioning or horses or castles or anything like that, right? Any word, they put it in alphabetical order, so you get like some of the George II, Edward, William and Mary, all different statutes, but law, it's just like an index of relevance to particular subjects. And this one's under Parliament. So this George II clause does not seem to differentiate between the House of Lords or House of Commons. It just says that persons may prosecute actions against members of Parliament, unless it means MPs, a member of Parliament, an MP. Maybe it means like MP, members of Parliament, but does it mean members of the House of Lords as well? Now, depending on that Magna Carta clause to do with barons and lords can only be judged by their equals, Jeremy Johnson KC, or QC at the time, in that paper, he does not use Magna Carta at all as a reference point of law in that paper. Now, the question that I've got, which I have yet to... There's only 4 clauses of Magna Carta in effect still, even though the document says that it can't be annulled, but, you know, part of it's been annulled. I don't know. Part of the deal with that document is that you can't annul it, it can't be annulled. There's a legal argument over that probably in the courts, but they've got 4 clauses in effect. The clause over barons and lords only being prosecuted by their equals, we know through that William and Mary all the dialogue from the 1688 Bill of Rights from the Parliament sessions I've got now and put up, they are prosecuting members of Parliament and lords and all manner of different rank and file people of title, because some of them were exempted out of that Indemnity Act as well. So that's 1688. So that's been prosecuted by their equals, though. That is being prosecuted by their equals, though, because that's the King and Parliament doing it, not anyone else. So that wouldn't really matter whether Magna Carta was in effect or not, that clause. But the question is, if the whole entirety of Magna Carta is not in effect now, when was it taken out of effect, or when were only certain clauses put into effect? I'm guessing, this is my guess at this stage now, I probably should have researched this already, but I'm guessing that, my guess is that if this here, this is just a simple equation, and that equation is if this here means, the equation is if this little bit here means is equal to both houses, Commons and Lords, then answer equals, it's likely that that is why this applies to both houses, on the point that if that Magna Carta clause of Barons and Lords was, well, it has been revoked and repealed. It's not in effect anymore, that Magna Carta clause. So that would explain if this ties in any linear way to that Magna Carta clause not being in effect from whatever point, then that would explain this, and it would prove how and why this applies to both houses. If that Magna Carta clause of Lords and Barons was still in effect at the time of this George II, then it would only be the House of Commons. But they could still, if you are another peer, then you could prosecute them in between sessions. But it wouldn't need to be in between sessions, surely. I'm sure that the Constitution of the United States, senators can just they can just stop halfway through and just go, right, if one of them is breaks the law in session, 2/3 of the Congress can just do them there and then. I think they can just say, right, whatever, they can just do them. If give them a fair trial. I think they can have a trial in Congress if they've got enough time for it, just there and then. I don't know whether that means that even Lords and Barons can only be judged by their equals in session, but it's in the thing is, right, so we'll go to what Johnson does say. Johnson doesn't mention this, right? I'm guessing that, this is my guess, the Crown Prosecution Service thought they could prosecute Hanningfield, right? And he'd been prosecuted before. So he's got to have been prosecuted, surely he can't be prosecuted on the Magna Carta basis, or this is the basis that it must have been prosecuted on, what the CPS thought they could prosecute him on this basis, surely. So the thing is that the CPS just thought that they'd already prosecuted him and some other people. Now, while they were in the court, then this document, this 6-page representation, turns up through email. Apparently, it was emailed in at the last minute, so we're told by the newspapers, whether we can believe them or not. And they just gave it to Alistair McCreef, and he's read it, and he's apparently he stopped it and said not guilty. I don't think the jury could hear the evidence. Now, the thing is that how did Lord Hanningfield... The thing is, right, Hanningfield had been prosecuted before, but how did he get into prosecution? I've heard Rees Mogg, even though he's not meant to be on GB News, I've heard him on GB News say that, apparently the Privileges Committee was faulty from the start. If the Privileges... What is the Privileges Committee in the Commons and the Lords? Well, it evaluates complaints or charges against ministers, and basically that's what happened with Johnson, isn't it? Now the thing is, that's their peers making a decision on a complaint, isn't it? Now the thing is, if it is, let's use the Lords for example. The Lords Privileges Committee, I have not read up on the Lords Privileges Committee. I haven't read all their jargon. I could do, but this is what I'm going from the other legislation. If the Privileges Committee consists of their peers, right, and there's been a complaint or charge against them, well, this is the thing. If it's connected with Parliament business, then they can only be judged by their... Well, the thing is, when the Privileges Committee looks at something and makes a decision like, oh, this falls under... So with Lord Haddingfield, right, what it's looking like is that with Haddingfield, right, he was in court in Southwark, in not the Old Bailey, in Southwark, Crown Court, and they said, oh, he falls under House of Lords jurisdiction. That's what they said in this paper. So they're saying that all the matters to do, that the facts and circumstances around these activities fall under House of Lords jurisdiction, right? That's what it's looking like. So therefore, he can't be prosecuted by the courts because it's not the court. It's the legislation that Johnson uses for Haddingfield is in the Bill of Rights, not our right to petition, but the illegal prosecutions by the King's Bench, which is meant to be tied in with our right, really. Illegal prosecutions by the King's Bench for matters only decidable, recognisable in Parliament, debatable in Parliament. That's Parliament work, right? That's the only law that Johnson uses in this representation here. On that basis, therefore, the only claim that he can make on that legislation is that Haddingfield's activities fall within that remit of parliamentary work, even though it wasn't in Parliament. That's the basis of it. But how did he get into court, though? How did he get into court at Southwark with the CPS? Because with the CPS, just because they thought they prosecuted him before, did they just prosecute him on this basis that, oh, we can just prosecute him in between sessions, right? And if the Lords are invoking or calling him under parliamentary privilege, right? Surely, this is my focal bit on it all now, the pivotal point of it with Haddingfield, and that is that if his Privileges Committee had received a complaint about his conduct or looked at it, which they're meant to do for all members, and a decision was made from that Privileges Committee in the Lords, not to put him under, not to say that it wasn't under parliamentary remit, then how can they at a later stage change their mind? Because really, isn't at that point that aren't they making a judgment, aren't his peers making a judgment in the Privileges Committee? Aren't his own peers in the Lords entering a decision on that? And if that decision is that he can be prosecuted, right? Firstly, if he's been judged by his peers in the Privileges Committee, isn't that them deciding that, if they're acting as jury, as a committee, then isn't he getting a judgment there and then? And shouldn't he have been processed duly? Or, did they refer him to the Old Bailey? Why didn't they refer him to the Supreme Court in the first place? You see, the thing is, not assisting offenders, what do you call it? not assisting offenders, the Corrupt and Illegal Practices Prevention Act and the Corrupt Practices Act, which sets out all procedures. It's got a load of stuff to do with privileges and lords in there. That's why the election prosecuting an election is special, and it the thing is, right, actually something just come to my mind now, and this is quite important, and that is that if you're in an election petition and it's being prosecuted for some kind of election fraud to do with the election, right, and there are witnesses being called or even being prosecuted, it says that it mentions the use of privilege, right? But firstly, right, this is a corker. This has got to be a corker, right? This is really important for anyone to understand this, right? If, right, how have you ended up? Okay, if you're a witness, right? Okay, you could be a witness with privilege, like some member of the House of Lords or Commons with privilege as a witness, but you could also stand as a candidate, right? Now, candidates are allowed to run for election if they've already got another position or if they're continuing their position, right? But it says that privilege can't be used to evade, proceedings or answering questions or even possibly even... It even says, like, possibly even being prosecuted, right? Firstly, members of Parliament, the government, aren't supposed to be allowed to help in elections or help the outcome of an election. This is the thing we've got with, this Simon Forthrop, Councillor Simon Forthrop, and another councillor from Harrow, that Goodwin or whatever he's called, who's helping Sue Hall. But he's the councillor, right? If you've got privilege, right, you've got privilege because you are a member of the government. If they call Hanningfield under the wing arm of privilege, right, for his affairs out of Parliament and say, oh, that's Parliament work, right? This is a corker, this, right? If Hanningfield and his shenanigans and activities outside Parliament are covered under parliamentary privilege because they say, we decide what's work for Parliament, or that falls under work for Parliament, right? Contrary to what it says here, that people can be prosecuted between sessions. Oh no, well, what would this, this is like, a lot of Adonis going around on the trains doing observations, work, investigation work for Parliament on the trains. Just like, it's not complicated. It's just like, I'm a police officer. Police officers don't only do police work in the police station or in the court, do they? They do it out and about. That is what Lord Hanningfield's paper effectively is about, I think. That, lords have got lords' business and work out and about, the job's just not in a building, like the police. Otherwise, the police wouldn't be allowed to have loads of clauses in all their actions and activities, racing down the motorway or kicking doors in, they'd just be under the legislation like us. Their work is restricted to a county, isn't it? It's restricted to the commission of the county for which that they are under the jurisdiction, which creates that authority. So it does have a border. It has a border of a county. Now, I think what Jeremy Johnson's argument is about the House of Lords is kind of like the jurisdiction of all England, isn't it? So you can go around there everywhere, like the assizes, circuits and so forth. Now, the thing is, right, that if all these shenanigans of the Lords, right, and you could say ministers of Parliament can extend beyond Parliament out and about, and, that all this is all work for Parliament. Firstly, what's Suella Braverman doing getting speeding offences and charges? Although I think there's one clause, I did find a clause in this index that says apparently that you can't get a pardon for highways offences, an old law. But privilege is not a pardon. Privilege the act of indemnity applies, and you have to be exempted out of the act of indemnity. With a pardon, you have to go pursue a pardon like an appeal. It's not something that applies and has to be unapplied, if you see what I mean. Because if you've got a privilege, then it applies where you're using it. The police get exempted out of the right to detain a person. They've got the right to detain a person pursuant of the law, unless it's found that they've harmed them in some way. But this sort of, I mean, it might be a bit complicated for people, this, because it's quite. You have to, it'd be alright if you could make a cartoon about it, or draw kind of little model or scenario to kind of exemplify it, rather than just saying it. But effectively, parliamentary privilege is not a pardon. You've got it in the first place, so you'd have to be exempted out of it. I think that's what the Privileges Committee kind of do. I think the Privileges Committee is meant to be sort of a little bit like the act of the act of indemnity is an act of legislation. But if the Privileges Committee said that this didn't fall under the work of Parliament or whatever, then I think that would be comparable to an act themselves, an act exempting them out of the privilege, if you see what I mean, the indemnity of the privilege. I don't know what happened with Johnson. I think that they found that he had done wrong, but his punishment was not apparently to be. His sentence was. He was asked to voluntarily step down, wasn't he? I don't think that they're exercising jurisdiction, which is funny because Lord Hangfield got justice, and that's meant to be higher than the Commons. If Hanningfield can go to prison, why didn't Johnson go to prison? Although, he's got a wife and kids and all that, and he'd all been to hospital and been poorly and the rest of it. So I don't know whether that's pity or what. But we don't seem to be getting these legal sentencing impeachments from the direction of House of Lords and Parliament for some reason. Now, how did Hanningfield? So Hanningfield ended up. I don't know how he ended up in the Old Bailey. That's the thing. If he'd been prosecuted before, did the CPS just process him as a normal person? And if so, I thought all accusations and crimes against members of the House had to be reported to the Privileges Committee. Now, if they had said, "Oh, go ahead and prosecute him," isn't that a peer decision? And what if at a later stage they're coming back and saying, "Oh no, now this is Parliament work"? How many times does it take them to decide whether it is or is not Parliament work or not? That's almost like really going to a jury, getting convicted, and then a week later them writing to you and saying, "Oh, the jury have said, they changed their mind." Can you do that? The jury have changed their mind. Lord Hangfield's peers in his Privileges Committee have changed their mind now. Now they're saying it does fall under the work of Parliament. Well, that's all right for some. Talk about double jeopardy. It seems like they can just keep changing their mind on verdicts all the time. Which is what definitely we don't get that privilege of getting the courts changing their mind all the time. Although it does say that you can you're meant to be able to write to the magistrates' court and get them. They never do. They never do change their mind unless you're ill or something like that. But look again at this matter. You go to the magistrates' court to get the judges to look again at this matter, but they never do. Because their conscience, does not is like steel. It doesn't bend or break. It just stays, strong. So it scratches my head with Braverman because if you can't have a pardon for highways offences, but it's not a pardon, is it? Because you have to get prosecuted in the first place for it to be a pardon. So there's nothing to say that highways offences aren't covered by privilege, or else the police won't be able to do their job. Because in a way, really, all the police clauses in law are enacted because there's an underlying right and privilege that exists, so they enacted it into the legislation, just like the Town and Country Planning Act 2007 and 1990 with the use of materials that we're allowed to do without consent or permission required in law. So with coming back to the elections, so what is a corker really is that if Hanningfield and his friends and pals, if their work can, extend beyond Parliament, which really it should do, because, an MP's office, an MP has an office, doesn't he, every constituency office where you can go in and have a surgery with the MP. That's Parliament work, isn't it, right? The law, I don't know if you can't go, I don't think you can go see the Lords like that. But if it does extend like that, then surely that Hanningfield case and his activities that fall under the Lord's jurisdiction, shouldn't that model apply not only for members of the House of Commons, but also for local councillors? Right? And if that's the case, then, I know councillors, it isn't work for Parliament. Councillors' work isn't work for Parliament. But if the model for Hanningfield is generally applicable, similarly to councillors, although it's not parliamentary jurisdiction, that would mean that, when councillors are knocking around out and about, they're always, available for work for the council. Come and look at Skip or whatever, once moving or other things like that. Like, or there's a problem somewhere. They're on call out. So how can they help and assist with elections? Because the council can't help with elections or affect the outcome of elections, because, if someone's giving a speech about voting in elections and then the local councillor passes them the microphone or lifts them up onto the stage or plugs in the amp unit, then he's just he has facilitated the a party political message in an election. He's just, he's engaging and assisting in the providing for the voice of the even speaking. I mean, Councillor Simon Forthrop was actually speaking himself, speaking to the microphone. I don't know what movie that's from. That's speaking to the microphone. So it seems that these election petition prosecutions with privilege. I mean, what if you've got, how would you be in an election petition if you've got privilege? Because only members of the government have privilege, really, Commons and Lords. So why would you be giving evidence or appearing in it if you're not allowed to get involved in an election? Unless you are getting re-elected, but the election is not work for Parliament, is it? The election can't be work for Parliament because it's meant to be run separately and independently. The government can't help the outcome of any political party in election or voting or influence it, right? Which is all of the flyering, the promo, So I can't understand how can anyone who would have privilege, but what effectively Hanningfield's, what they're saying is that certain activities extend to cover you when you're out and about or not necessarily in the chamber, and that's how Hanningfield got out of being prosecuted, right? So let's say Hanningfield, let's just say Susan Hall, like this is an example, right? So this is probably the best example, right? Let's say Susan Hall is running for Mayor of London, like now, right? And let's say Lord Hanningfield, for example, or Lord Adonis is helping her out, set a microphone up and plug it in and then pass it up to her, and even gives a little speech, like with Simon Forthrop, what he voted for Susan Hall, right? Now you're talking, now you're getting prosecuted. Oh, no, you're not allowed to use privilege to get out of answering questions, right? Well, they can't use a privilege to get out of answering questions, but the fact that it is a person who is not the candidate who is using privilege, what are you doing helping someone to get elected when the government can't help them get elected? If you've got privilege, then you're acting on behalf of the government through government powers. So if that ain't the government helping them, I don't know what is. Unless you just... If you're not helping them, but you've got the privilege, is the proceedings, being called to court in proceedings, isn't work for Parliament, right? So why would you be using the privilege? Because this is really complicated, right? If you can be prosecuted in between sessions, and that is not regarded as work for Parliament, right? In between sessions, you turn up at an election petition, right? So if in between sessions you turn up at an election petition, then that is the same as being able to be prosecuted. But in the election petition, it's saying that, yeah, you can answer questions and so forth, right? And even get prosecuted, but it's questionable about the punishments. But what would you be doing in an election petition if you're not allowed to help one? If you're not allowed to help the outcome of an election, what would you be doing getting involved with it anyway? Or is that the point? You know, and if you can be an election petition as someone with privilege, and even if you've been engaging in assisting, which is against the law, then what is Lord Ironfield doing not getting prosecuted in Suffolk Crown Court, you know, in between sessions? That really stumps me. And if he does anything wrong and he's reported to the police, don't the CPS have to tell the Privileges Committee anyway in the first place? And when the Privileges Committee are his peers and have to make his peers make a decision on a legal challenge against him, after they've made that decision, clearly something has to be done with the Privileges Committee. He ends up in Suffolk Crown Court, but then they change their mind. Apparently they can have a second opinion. You know, it's almost like Ian Bray, you know. Does Ian Bray get called back in? Or what about Angela Ditchfield? Even though Angela Ditchfield was acquitted, who's calling her back in? Oh no, the prosecutor wants to have another go at her, you know. I've heard of the prosecutor wanting to have another go at someone, but I've never heard of a jury wanting to have another go at someone, you know. Was the jury's decision is final? I think sometimes they can have I was reading the other day, they can have reservations about things, but usually juries don't. That's it, the proceedings, because the jury and the judge and the clerk and the court are meant to be the indifferent party. It's the Crown Prosecutor who's bringing the charge with the police, right? Although the police are meant to be unbiased, but as the evidence shows, as the evidence dictates, the prosecutors pushed for it with Angela Ditchfield, even though she was acquitted. That wasn't the court itself. So, you know, the thing with the Lords judging their peers, but there's a thing with the committee is meant, I'll bring us into it, like all that dialogue with William Orange in Parliament is like, he's referring, the King can make a decision with his assembly there and then, or he can refer it to a committee and them to make a decision. When he refers it to the committee to make a decision, I'm sure they are actually making the order, you know, and one of them get a bill put through for it or something. Although I don't know how it works, though, if they refer it to a committee to decide. But then what happens, you know, when you get bills put through, they put a bill through the other day to stop ULEZ, but Labour voted against it. What if committees are making decisions on behalf of the government for actions? What's the point in having a committee to deal with it if the House vote for or against it? Or are the committees supposed to be kind of like preparing it and then acting as the prosecutor in front of the House to vote on it, or just preparing it indifferently for the House to vote on it, or what? or the committee supposed to be making a vote on it and an order? You know, I know the petitions committee's got powers to summon documents and people. Obviously, for what though? The privileges committee's got the power to summon documents and people, so they can have a little kind of inquiry style proceeding. But in the Inquiries Act, the court can't prosecute people. It has to refer it to the High Court. Now, you're saying that Parliament has to refer things to the High Court, like the Inquiries Act 2005 has to refer people to the Crown Court. Why did I say that? The Inquiries Act 2005 has to refer people to the High Court, not the Crown Court, the High Court. I got that right. I don't know why I said Crown Court, High Court. Now, does Parliament refer people to a court? Or does it make a decision or order itself? Well, with the post office scandal, apparently Tice was saying that they put bills through. You got a bill put through. So they aren't referring it to the Supreme or High Court, are they? They're getting a bill put through. But when you put the bill through to do it, then that goes through to the House of Lords, right? But they said that, the House of Lords can't deal with criminal matters, which is a lie, because they are doing. They just pulled the Appeal Act Jurisdiction Act, where you don't appeal by petition and prayer to the Lords. This whole Supreme Court, High Court shenanigans seems to me like a cup and ball trick. Why they refer Angela Ditchfield to the High Court, the CPS taker there, but with Haddingfield, right? Why didn't the CPS appeal to the Supreme Court with Haddingfield, right? Or why didn't they call, an investigation into his behaviour through like the election petition process, whereby it's kind of civil inquiry, but with a prosecutor present. Although they call it a trial still, though, which is quite odd. Well, it's meant to be a peculiar kind of proceedings. The whole affair seems to be a peculiar kind of proceedings to me. I'm not confusing matters here. I'm just kind of like, I think they're making it up as they go along. Like Assange also, with this whole detaining Assange against rights, are they saying that Assange doesn't have any rights in England? But the rights in England are the rights to whoever is in England. Because those are the rights that apply to people who get put through the system, surely. So, how does all this bear on us and our rights? Well, I think how it bears on us is that it needs to be recognised that the petition and the signatures is actually, you need evidence for it, and you need to obtain that evidence, and you need to promote it to the public to get evidence of public concern, more witnesses and supporters, and that those activities that take place in public, and that is who is the case to and with Parliament, because that's and those are where the proceedings apply, and it's a national jurisdiction, and really it's the same as Haddingfield. But what decides whether you are? You see, the Privileges Committee the Lords were deciding that Haddingfield fell under their jurisdiction. I think that's the point. And the point is that who decides that we fall under Parliament jurisdiction? Well, we've decided Haddingfield's peers are the ones who are engaged with his work. And when we are engaged with work, it's meant to be engaged with Parliament, actually, the Petitions Committee, and the people who signed it. Sort of just like if you have a court case. And I don't know why we're not getting acknowledged for that. And the basis of the Town and Country Planning Act shows at least one act of law where there's you get effectively exempted out of the act with deemed an express consent. So it's actually in legislation, and that's what Max Hill ignored. Max Hill ignored it. But the thing is, with Max Hill and the CPS, that act is very detailed and thorough. It describes and explains the whole thing in extraordinary detail, in very specific explanatory terms, in a wide variety and extensive context. And it's almost like an explainer, a walkthrough. You know, like when you get a computer game and you don't know how to do it, so, you get the TV guide, you don't need the TV. It's like, it guides you through, walk down the corridor, turn right. It's like a full set of instructions on how to do it and what to do. It's like getting a computer game with the instruction manual. It's like getting a fridge, right? You get a new fridge and you don't know how to work it. You get the manual out and it tells you how to work it, right? Now, with Faulty Towers and Max Hill, it's like he got a new TV set, right? And he couldn't turn it on, right? It won't work. That's why he get the manual out. Well, what would be the equivalent manual for Angela Ditchfield? Well, with the Town and Country Planning Act is the manual for what she did. So if you get like a Samsung TV, a 169, you want the Samsung 169 manual, right? So if you're painting a political logos on a wall or on the surface of anything, and using signs, you want the sign and painting manual. What is the sign and painting manual? Is a Town and Country Planning Act, right, which tells you all about it, including naughties and penalties and even, fines and other, and all, the whole thing. It's like the manual, the A to Z explainer in full detail. So what I can understand with Max Hill is, if you've got like a Samsung TV, why did he get like, a Toshiba manual out, which is like the equivalent of the Criminal Damage Act, and use it on Angela Ditchfield, even though she'd been acquitted? Well, that's, but then he tried again. It's almost like trying to get a TV. If you're trying to get a TV to work, right? So you're trying to get a television to work and you can't find the on button, like where is the on button? And you get the manual out, right? But no, this guy, Max Hill, like the TV, he can't find, he can't turn the TV on, so he gets a fucking sledgehammer and he just, bangs it, and then it still didn't work, Angela Ditchfield, not guilty, right? So, bang it a bit harder, take it to the High Court, That's effectively what Max Hill and the police are doing to people, this person's not working properly. Well, how do you get the manual out and see what's wrong? That's, no, we don't want that manual. Why? Because it says there's no problem here. The Town and Country Planning Act says, there's no offence here, there's no crime, there's no problem. No, that's, this is not right. I'm not getting the right picture on the TV that I want. This is like Max Hill, tuning into the Not Guilty channel, like, I don't like the Not Guilty channel, like, so put his foot through the fucking TV, that's what the police do, the police doesn't like TV fucking channel, so he puts his foot through it, This is what these people are doing, though, but they're just continuing, how are these Crown prosecutors, judges, people still in a job? But this is what we're getting from the American government now. This Chris Carr, RICO charges with Stop Cop City, and then now this other monkey, this prosecutor, American prosecutor, who's saying that Assange doesn't have any rights in America yet, which is total tosh. I've explained in great detail how Assange must have and can't not have rights in America, based on several factors to do with the court process, federal question proceedings, buying properties, and court of civil requests. The petition is court of civil requests. That's what it was. I've got a petition for Parliament. Okay, it was court of civil requests. You got over 20 people. It's a civil request, right? Now must have privileges applied. Now, does that mean that, there's another next case, please, court of civil requests, or can I get my house extended? It's Julian Assange, he's an Australian fellow, he'd like to buy an apartment in London. Oh, I'm sorry, Australians can't have property in England, you don't have any rights here. Well, what am I doing in the court of civil requests then? Can I make a civil request? Can I petition the king? I'm Julian Assange, I'm in the court of civil requests. I'd like to buy a flat in London, please. No, I'm sorry, Australians can't buy property in England. That's not true. Okay, go on then. I'd like to extend. Okay, fine. Actually, no, we're not going to allow extension of the building. Well, I'm appeal for a resolution to Parliament then. I'll appeal for a resolution to Parliament through the Courts Act 2003. Appeal for a resolution to either of houses of Parliament to get my flat extended. And Julian Assange, the Australian, and Court of Civil Requests. This is it. But apparently Biden says no. This is Crown prosecutor, RICO charges. Chris Carr says no. But Court of Civil Requests says yes. Or, they're not even... I'm even having to fight for this right to appeal Parliament at the moment, or either of the Houses of Parliament, through the local council planning application, which I prosecuted them not prosecuted them, I brought a civil action against them, and then I realised that, just a minute, you can raise this to Parliament, which is what I'm trying to do now, but it says that their order is subject to annulment in pursuant of a resolution from Parliament. So that means that they can't start development work on the town centre, and I've got a right to collect 100,000 signatures on it, or try, but they're delaying it, and I really don't know what's happening now with that. Save the details. You apparently got a right to do it. I can't see how the Americans, if the Americans adopted the petitioning in the First Amendment, I can't see how they can have court of civil requests in America, or federal question legislation. If you can't do it when you're a foreigner, because you can. That's what it is, isn't it? Court of civil requests is what you brought petitions to Parliament through, and you can petition over anything. Now, even if Assange himself, the ironic thing is this: Assange effectively could buy a house. Oh no, actually, not if he was Egyptian, because we didn't used to allow Egyptians into England, did we? Assange wouldn't have been allowed to buy a house in England if he was an Egyptian, like in the 1600s, because Egyptians weren't allowed in England. But I think Australians are allowed in now. I think you're allowed into this country of any nationality. I don't know if you can buy a property here or not, unless you've got citizenship. I'm not sure about that. I don't know whether you can buy a property unless you're a citizen or not. Oh no, because don't Americans buy... surely some if you've got a business, that you have to have it incorporated in England. You're getting into the realm of business now. And I think that, what about lobbying the government? Surely there is some... The thing with Biden and the whole American government is, what about lobbying from companies that are overseas? Well, is that not laying something to Parliament and proceedings? With Congress. It's the equivalent of Parliament, Congress. What about all these lobbyists? I wouldn't be surprised. I bet Biden's been given the equivalent of American rights to First Amendment rights to lobbyists. Even if they don't live in America, I wouldn't be surprised if they've got if they own businesses there, Russian business gurus or whatever. I won't be surprised if they actually have been equivalently granting them political rights when they've been laying bills to Congress or trying to lobby Congress to get federal law changed or whatever, because they have been doing, haven't they? What about all that? I'm sure they've been granting it to businesses and companies that aren't based in England. But you wouldn't be. How can you even lobby the bill if you're not from the country or lay a bill? The process of laying the bill grants the rights that apply to those type of actions and proceedings, surely. Or you can't lay it. You see, the thing with Biden and co is they want it all their way, don't they? Like, oh, it's, you know, if it's business, then we can do it. But then if it's a private matter, then no, you can't do it, or Assange can't do it.